Indonesia, the world's largest archipelagic country and an emerging Southeast Asian nation. Focusing on a rapid pace of development and business growth, the government is working hard to reform and simplify the country's various regulations and legal frameworks to boost national economic growth. Through the issuance of the Job Creation Law, the government sets new standards for employment concepts and rules to broaden the job opportunities for Indonesian workers. The Omnibus Law merely revoked certain provisions under the prior Manpower Law and issued some important implementing regulations. This must be anticipated by employers to minimize business risks. With the experience of more than 1 decade, ADCO has wide-ranging knowledge and extensive experience in handling all types of employment issues. ADCO has experience in assisting disputing parties, both employers and employees, from industrial disputes, termination, and work formalities. We have successfully assisted one of the biggest stainless steel companies in Indonesia in a mass termination of their employees. We guided the company throughout the termination process to always comply with the regulations and assisted the company with thorough investigations of all business and legal risks. ADCO is also trusted by one of the largest social agencies in the Asia-Pacific region to give them legal advice to mitigate risks related to severance packages in accordance with Indonesian employment law. We also have broad experience in representing employees who are facing an unlawful termination process, where we successfully assisted them through dispute resolutions at the Industrial Relations Court in Indonesia. ADCO earns the trust to represent clients from multinational companies to emerging entities across a wide range of industries to achieve their business objectives in Indonesia. We strive to help you overcome the challenges of competition in the global economy.
Good morning, ladies and gentlemen. Welcome to today's dialogue at ADCOTalks 2023, Thinking Outside Pandora's Box. A dialogue stems from the firm's awareness of the 2023 global recession that not only destabilizes currencies and leads to corporate actions such as mergers and acquisitions as part of its impact at the micro level, but also at the macro level where nations are confronted with declining and complex economic and fiscal conditions that necessitate debt restructuring facilities. Once again, we welcome all attendees, including the invited guests, our respected clients, partners, and other stakeholders. Participants, today's ADCOTalks are not only held through the Zoom webinar, but also broadcast live on ADCO YouTube. For your convenience, today's discussion will be divided into 2 sessions. The first session will last until 10:50 a.m. Jakarta time. We will continue the second session on the same Zoom link from 13 to 15. So make sure you attend both dialogue sessions because there will be a plethora of details about the 2023 global recession. At the end of each session, we also opened a question and answer time. So for those of you who would like to ask questions, please do so by putting your questions in the Q&A feature at the bottom of your Zoom screen. Please do not hesitate to ask in Bahasa Indonesia. Before I go, I would like to greet the moderator for this first session, Christopher Johnston. Chris, welcome. How are you, Chris?
100%, Lisa. Thanks so much. I'm so happy to be here today. How are you doing?
I'm so good. Fantastic, Chris. I'm fantastic. Of course, we cannot wait to get started in the first session. Ladies and gentlemen, before we begin the dialogue, please welcome Dendi Adisuryo, ADCOTalks partner, who will deliver the opening remarks. Dendi, the stage is yours.
Thank you, Liza. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. Good morning, Bapak, Ibu, ladies and gentlemen, all distinguished participants. Thank you for attending this meeting. Based on the list that I obtained from the business development and organizer of this event, the attendees are about 140, not 150. And I think that number, I'm very grateful to have that much participant attending this webinar. And also I want to welcome and thanks to all the speakers. We have here Morales Sundusing, our legal counsel in ADCO, and also Ibu Alexandra Gerungan. I call Mbak Alex actually, yes, not Ibu Alex, yeah. And also our special guest speakers here, my friend Pak James Morrison from Peter and Kim. Once again, thanks for the three of you to allocate your time and spending your precious time and becoming a speaker in this event. So actually, I'm given only 5 minutes opening time, so I will make it very short. Yeah, like you may know that this webinar is actually our regular event. Maybe once or in a month or in 2 months, we have this kind of webinar to share knowledge, update, experience about the legal practice, not only in Indonesia, but also from other jurisdictions. And especially for this event, the topic is the anticipating the global recession on 2023. There will be 2 sessions, right, Lisa? And for this morning sessions, we will be focusing on the a potential dispute that may come along with the global recessions. Yeah, because we have a couple of experience in 1998, in 28 and 2020, yeah, and now in 2023 when the global recession is coming in, then the potential dispute is rising. So that's why we want to have all the speakers to share your view on this, and also for the all participants. I hope you can enjoy the webinar and take some sort of key takeaways for your business activities. Okay, once again, thank you. And also thanks for the organizing committee for this. Back to you, Liza. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you for the warm welcome, Pak Dendi Adisuryo. We will soon begin the first dialogue session, various threats of 2023 global recession, impacts and settlement forums. Once again, I remind you who want to ask questions, please do so in the Q&A feature, and you can ask your questions in Bahasa Indonesia. I wish you all a fruitful dialogue. Please welcome our moderator, Christopher Johnston.
Thank you, Lisa, for that fantastic introduction. It's a real pleasure to be here. And when I heard that the title was about Pandora's box, obviously things aren't looking good. In 2022, we had a pandemic and also a major European war. And so, yeah, what is awaiting us in 2023? So the idea today is to have a brainstorming session, and that's why the talks are quite short, but the Q&A will actually be quite long. So the brainstorming, the idea is to think outside the box, outside of Pandora's box, without slipping off the Möbius strip. And the idea here is that we're at a very unusual moment in history. I think usually when there's a crisis, we don't know there'll be a crisis, right? When there's a pandemic or a war, it's unexpected. But actually in this area, we are at a crucial moment. And yes, there is such a word, a crucial. So not crucial, but crucial, meaning that there is a pivot coming. And we have the opportunity to pivot away or to react to a crisis. So we know the crisis is coming. And it's very unusual where Bloomberg and Reuters, they say that the chance of a recession is 100%. So this is this is very unusual. We cannot let this go to waste. We must react, and it's quite incredible, you know. Is it Pandora's box or Batman trap, you know, as they say in Indonesia? Is it really coming? That's what we're going to discuss today. Is it, you know, what sort of risk mitigating features, measures can we take? And I think that law firms have a very important role to play. Normally we see governments as the only agency, but actually at this time, perhaps we can conceive of a concept, and this is the overarching theme of this webinar today, is that law firms actually have a role to play. We can mitigate the risk. We can prepare action plans. We don't just react, but we are proactive. And so I would like to start off with an idea which is maybe a bit contrarian or maybe trite. And that is that perhaps the secret might be customer service. I mean, that sounds rather trite when there's a huge recession coming, but one of the themes today is that restructuring is not always a bad thing, right? When you're restructuring, actually we're becoming more nimble. So we are not necessarily, maybe you downsize the sales department, but at the same time, you can strengthen your customer service, because that's what clients remember, right, in your company, is how you dealt with the crisis. Client retention is just as important. So that's an insight. We'll see if that pans out, because what we're trying to develop today in our own way is a sort of action plan. So that's why we have set this up rather intelligently, I must say, with a litigation section. So we will discuss litigation, because in theory, if you have PKPU, if you have bankruptcies, insolvencies, suspension of payment, logically, you will have litigation. So we will discuss developing trends. And if you have litigation and downsizing, logically, you will have employment issues. So that's why we will be discussing employment, downsizing, restructuring. Basically, companies not necessarily shutting down, but that might be a consequence, but some sort of corporate action in anticipation. You know, if you want to put it as a metaphor, you know, it's as if we can see Godzilla on the horizon. You know? So usually you're just hit by a crisis, but this time we can see the tsunami, we can see the zombie horde coming. So we have time to plan. We have time to enact risk mitigating measures, corporate action, and we will be discussing some of them. If, however, push comes to shove, we might find ourselves in the halls of Maxwell Center, where I'm sure James Morrison, he often frequents, and you will be looking at arbitration at SEAC. And we will also discuss how that might pan out, the suluk buluk, you know, the ins and outs, the nuances there. It's not all conjecture. In fact, we do see that there is potentially a tech winter. And I hate to say, but when I said Pandora box or Batman trap, it does look more like Pandora box, because as you know, when you open Pandora's box, you cannot close it again. And the tech winter, my friends, is upon us. Anecdotally from friends, I have heard of mass layoffs and even people hired in order to fire everyone. So I have heard some stories in tech companies where friends of mine have been hired in order to fire almost everyone in the company. So it is coming to pass, at least in the tech sector. I think a lot of the free money that has been just used to burn, that time is actually maybe up, and we're going to see a lot of creative destruction. So today, we have three key speakers in the first section. And the first one will be our own Alex, Ibu Alex. She had her BA from University Indonesia and her LLM at Leiden. She is a partner at ADCO Law, and her specialty is litigation. And the second speaker is Morales Sundusing. Morales is counsel at ADCO Law, and he also did a special course in Beijing at the Youth Academy. He speaks English, Indonesian, Chinese, among many other languages, I'm sure. And our third speaker from Peter and Kim is James Morrison. James is a seasoned arbitrator. He was an arbiter, he was a counsel at ICC, currently a partner at Peter and King. And he did his studies in Stockholm in commercial arbitration law. So what we've done is we've brought together these three very competent people who are in the swim, and they will be here to confirm some of the trends that I've been speaking about. Of course, the G20 looms in our minds because, you know, this has just happened. At this forum, I think there was a general consensus that we must all be nimble, we must be proactive. And with that, I'd like to turn the session over to Alex, Ibu Alex, who will speak to us on litigation and hopefully give us some very powerful insights. And the questions, please hold until the Q&A session. And so I give you the floor, Ibu Alex, silakan.
Thank you, Chris. Thank you, everyone, for attending this seminar. This is a very interesting topic, and I'm sure this has been questions also for many of us on how to cope with or how to go through the next year. So I will be sharing some insights based on my expertise in the litigation and dispute resolutions. I may start with looking at currently big countries' economies such as European, China, US are predicted to struggle over the coming months with consumers cutting back spending. This is anticipated to have a significant impact on Indonesia and, of course, other Southeast Asian exporters particularly. This is mainly because the US, EU, and China are among the top trading partners of many ASEAN countries, as well as Indonesia. We so far have probably seen the already declining values of coal, palm oil, tin, copper, and so on. It was predicted that retailers, manufacturers, infrastructures will also be impacted by the economic turmoil. What we can expect, anticipate, what will be coming are probably, I see at least four. First of all, there could be a higher risk of default in production and decline in production. This is because manufacturers may cut out capital spending, budget, and marketing to avoid future losses or to prevent more losses coming. This could eventually cause decrease in sales and failure to meet forecast or projected revenue. This would be hard for companies, especially those who have annual projected revenue, because failure to meet them may carry the consequence that the subsequent years target will be higher. Second matter could be is more disruption in sales and income could result in failure to make committed payments and obligations. This is where lawsuits, claims, and so on may come in play, because while the situation could be argued is beyond the control of the manufacturers or producers, the creditors may also have their own difficulties in recovering debts and NPLs. So this is one of the potential claims that we foresee could happen more in coming year. Bankruptcy, and the third is bankruptcy and insolvency. Yes, this is getting more in trend because bankruptcy, in bankruptcy proceeding, you can expect to have a ruling or a decision on your petition to have a company declared bankrupt in effectively a short term. So you don't have to wait for 1, 2, 3 years, such as happened in full litigated court proceeding. In bankruptcy, you can expect that in more in shorter period. The fourth one, I expect that companies may spend less on doing research and development and stop new product rollouts. This also result in projects, deals, and transactions ceased or put on hold, because companies may prefer to spend budgets and income in meeting obligations instead of doing new projects or entering into new deals and so on. In other terms, to survive or to not to incur more losses, or not to prevent potential claims for failure of making commitments. However, a study indicated that ASEAN is not really a stranger to surviving a recession. ASEAN countries experience minimum impact during the 2007 recession and recovered quite quickly from the economic downturn brought about by the COVID pandemic. As our President Jokowi mentioned in last weekend's gathering, Indonesia's economy managed to grow amid the storm of global recession. But we have to continue working hard to avoid an economic recession. So while the global economic turmoil looks dark, there are always hope and options to mitigate. And once we can overcome this recession, we can go further with business and operation. Some of mitigation measures that will always open. First is when you have projects ongoing or in pipeline, you can always propose or negotiate new term schedule, and so on. So instead of having extended and long court lawsuits and saga, you can spend more time in negotiating or proposing new terms in contract. For companies who are facing difficulties in making payments, but business is still running and there are hopes that everything will be better, restructuring loan and debt is always an option. It could be a win-win outcome for both parties, the debtor and creditor, because debtor can start making payments and creditors will start getting income and getting the debt recovered. Insolvency or bankruptcy proceeding is also one of the measures to get debt recovery, especially for companies who have limited assets, but quite a big chunk of obligation. But on the other hand, still hope that cash will still flow. So this could still be an option. One last thing is probably to change the operational structure and strategy to help company businesses remain agile. For example, this may not be a preferred measure, but closing branches or going digital instead of renting more space or opening new offices will cut losses. And so a company can focus more on the ongoing business and hopefully increase sales and productions. So you can start fulfilling commitments. Those are some practical, I hope, insights that we can get in anticipation of the economic recession in the coming year, and hopefully in looking to the next year, we will be there in about a month or so. We can still look at it with big hope, because hopefully we can learn from Jokowi's statement in the gathering last week that we can always work together to go through this. I think that's what I can share for now. Thank you, Chris.
Thank you so much. And we will have time in the Q&A to ask you questions. Right now, we'd like to turn to Mr. Morales, who will speak on employment downsizing. Mr. Morales, I give you the floor, sir.
Thank you, Chris. You don't need to mention Mr. because just call me Morales. And first of all, I would like to thank you everyone who participating in this discussion this morning, Chris. I'm so honored to be part of this event. I hope that you are still enjoying this event. For the next 5 minutes, I hope that I can share several things. Maybe we can discuss it further in the Q&A session. But, Chris, when I speak too much, more than 5 minutes, please remind me. I think numbers of people here cannot wait to hear further from James, right, James? So anyway, as Mbak Alex has previously addressed several legal threats in litigation and what could be expected in the near future in 2023, now I would like to briefly talk about a more specific topic which might be considered more sensitive problems and employment issue that, like it or not, sooner or later might happen in the future. But before I go any further, Chris, I would like to say to everyone who has already suffered as a result of this, we use the term of unfortunate condition for the past years, whether you are the employee or you are the employer. I would like to say that please be strong, don't worry, because in the end this too will pass eventually. As Mbak Alex in the beginning mentioned, that even our economic is growing during these downturns. And as I said earlier, whether we like it or not, when we discuss about economic crisis or economic recession, I would say that we will always be in touch with employment downsizing dilemmas, massive termination, employee layoff, and so on. Even I believe that everyone here in this Zoom agrees that discontinuing of employment relationship is not a sensible move at all, especially during an economic downturn. However, just like two sides of coins, Chris and everyone, sometimes if we see it in a larger context or in a broader sense, with this unwanted scenario maybe can also be considered, a way out to protect more. And please don't get me wrong, or please don't get the wrong idea, or do not misunderstand with what I just said, because please keep in mind that these are unwanted incidents after all. As a matter of fact, I believe that neither the employer nor the employee wants this to happen in the first place. However, if this downsizing, or I call it a way out, just can save maybe hundreds or even 1,000 of people, then sometimes that difficult path is necessary to be taken. Even in a legal point of view, from a legal perspective, downsizing of the employment, whether in form of layoffs, contract termination due to efficiency, or any types of downsizing, it is clearly permitted. It is clearly not prohibited. It is not something that forbidden. In fact, it is this downsizing issue is 100% allowed, as long as it is conducted in the right manner, and sometimes might be considered as a win-win situation for both parties, whether for the employer or the employee. So I think that's the main issue here in the downsizing matters, whether the parties involved, which is in this case is the company, really want to do it in accordance with the law or not. Because I believe that the employer sometimes not really, or most of the time not really intended to disobey the law. But most of the time, I think the employer is, simply not aware of the obligation that must be carried out in the event of downsizing, which of course might lead them to bigger losses if there is any legal action is brought against them, as maybe later Mbak Alex can add, or James in the commercial dispute can add. In fact, it may end up costing the company significantly more than it should, because litigation or arbitration is considered expensive. That's why I always advise my clients, my friends, or anyone who asks, at least they need preliminary legal guidance from a professional before engaging in any sort of downsizing inside their organization. Because even I said earlier that it is completely permitted by the law, it is allowed by the law, but Indonesian employment law itself has also mentioned explicitly in the regulation that the downsizing of the employment is the last resort if the employer has taken any possible alternative. Maybe Pak Chris in the beginning also mentioned maybe they can adjusting the production capacity in the company based on the, of course, analysis of the current demands, maybe cutting off several costs that can be taken, maybe SEO costs or any cost that can be cut off, or in some cases even the employer, the business actor, the company decided to change the business model within the company just to follow the current market or current trends. And when we talk about downsizing, last but not least, I would like to encourage all the employers, the company, to always remember that they have a legal obligation to guarantee the welfare of the employees. If I put my cards on the table, Chris, I would say that BPJS Ketenagakerjaan, BPJS Kesehatan program are still the most important measures that are available at the moment. But unfortunately and sadly, even as simple as BPJS Ketenagakerjaan and BPJS Kesehatan, many of business actors, company are not aware of this responsibility. Yeah, I think that's it from me for the beginning, Chris. Maybe we can discuss about this further during Q&A session. Thank you very much, Chris.
Thank you. Thank you so much, Morales. I'm sure there will be many questions during the Q&A session. That was very interesting. We're going to move on, though, to James Morrison. And very interesting, James. It seems you're looking at things from a macro perspective, which I find very, very interesting, very unusual. So please, I give you the floor. Welcome.
Thank you, Chris, and the ADCO team for this wonderful opportunity to speak in a great event and share some macro ideas about a difficult topic. Sometimes it's uncomfortable to even contemplate looking inside Pandora's box. But as dispute resolution specialists, sometimes we're constrained to do that. And that's what I'm going to do today. When sued at SEAC, what to do? Well, I want to start by sharing 5 hot tips, which I tell my clients when this happens. First, do not panic. The SEAC arbitration system is tried, it's tested, and can be trusted. And actually, it contains many protections for respondent parties. So while the recession and the prospect of recession might be a Pandora's box, SEAC arbitration certainly is not. Second, do not do nothing. The SEAC rules are expressly designed to move cases forward if respondent parties don't participate. The risk of an adverse decision against you, it increases greatly when you don't appear to argue your case. Third, do get experienced counsel. Instructing lawyers who are expert and experienced in SEAC arbitrations is crucial. And it is actually an investment in managing risk and maximizing your ability to obtain a favorable outcome. Fourth, do appoint a good tribunal. the most important step in an arbitration, especially for a respondent party. You need to work with your counsel to appoint arbitrators who are experienced in SEAC, expert at the subject matter, and importantly, who understand you, your culture, and your business. And finally, do get serious about winning. This obviously means winning in terms of result, but it's also an invitation to think more creatively about what winning means and how you win. For example, this could include considerations of promoting diversity, of counsel, of arbitrators. Also, ESG outcomes, environment, society, governance, and also e-arbitration. How can you use technology to increase efficiency in dispute resolution? And it's against that backdrop of my 5 hot tips that I now want to briefly touch upon the role of SEAC in economic conflicts between countries due to the looming global recession. Statistics from SEAC confirm that a significant consequence of global downturn is disputes upturn. The 2009 GFC is illustrative. In 2008, there were 99 new cases at SEAC, but this number doubled in 2010 to 198 new cases. The impact of serious economic shock is also reflected in SEAC's pandemic case numbers. In 2019, there were 454 new cases at SEAC. This jumped to an incredible 1,063 new cases in 2020. And just in 2021, the numbers dropped back to their pre-pandemic levels around the 450 mark. And SEAC will continue to play an especially important role for disputes in Southeast Asia in any looming global economic crisis. International surveys now consistently recognize SEAC is the most preferred arbitral institution in Asia Pacific, and Singapore is the most preferred seat in the region. And Indonesia, together with Malaysia and Vietnam, is now in the top 10 users of SEAC arbitration. And all of these trends, they've followed some important amendments and improvements to the SEAC rules, which were made after the GFC. And there are 6 recent features, which I just want to touch on very briefly. We can discuss them later if needed in the chat, which are now actually common procedures in dispute settlement at SEAC. 1, emergency arbitration. SEAC was one of the first institutions in the world to introduce an innovative procedure where urgent interim relief can be obtained from an emergency arbitrator even before the constitution of a tribunal. 2, investment arbitration rules. These specific rules have been adopted by SEAC to administer disputes involving states, intergovernmental organizations, and investors. The implications for global recession disputes is clear and how these can be applied. 3, expedited arbitration rules, where SEAC can fast track certain arbitrations within as little as 6 months by a sole arbitrator, possibly without a hearing, and by issuing an award with only summary instead of full reasons. 4, complex arbitration rules, where SEAC can deal with requests for joinder of third parties, consolidation of multiple arbitrations, and consolidation of multi-contract disputes. 5, scrutiny of draft awards. SEAC now makes suggestions to tribunals to assist in removing errors and improving reasoning in draft awards. This process ensures that SEAC awards are high quality and can maximize their enforceability for state courts. Finally, internationality. SEAC has seriously modernized as an arbitral institution since the 2009 GFC. The members of the SEAC Court and Secretariat are truly international and include significant representation from Southeast Asia. The staff and the court members are also recognized and leading specialists in international arbitration. I wanted to emphasize this point because I think it is actually really important, because users from this region can be assured that every time SEAC takes a procedural decision in a case or scrutinizes an arbitral award, the parties are in safe hands. This has all been conducted by people who understand their culture, understand their business background. So there are just a few introductory remarks I'd like to make. And I have sought to just give you some comfort about what to do when you're sued at SEAC. And I also want to demonstrate the added value that legal counsel who are experienced in SEAC arbitration can bring to manage risk and maximize outcomes in global recession disputes. Thanks very much, Chris.
Thank you so much, James. We're going to carry on with a discussion now. I think a lot of the comments have been tending in the same direction, and that is that we're looking at various risk mitigating factors. And after all, we have survived the COVID, right? So that was one of the worst episodes in many people's lives. Maybe 2023 will just be like a speed bump to us, it will be absolutely nothing. So the first point, I'd like to address it to the partner at ADCO, Alex, but anyone can jump in, if you have a comment, but that would be about the tech sector, because I think the startups really give a certain vibrancy, they make the economy dynamic. And if the startup sector is seriously depressed, I think that could be very, very bad news. What is your opinion, Alex, on the influence of the so-called tech winter?
Yes, thank you, Chris. Yes, that's interesting point because agreed. Learning from the how we survived and went through the pandemic, it looks like Indonesia and I think most of the Southeast Asia countries recovered quite quickly from the impact. In Indonesia, particularly, I saw that the economic downturn, we recovered from the economic downturn and lockdowns because especially the lockdown stimulated a transformation digitally of how we do business in Indonesia. And because many startups and many companies start doing their operation digitally. And from there, what I see is there is still room for growth, in fintech, health tech, and edtech sectors. But yes, I see also the trends that startups are doing layoffs, and that also impacts huge ones. And the main reason could be because investors are also dealing with the recession, especially because of the inflation rates and so on. And there is no there's less spending for investing in big startups. That's another thing is also because there is huge there are many huge mergers or many purchase of big startups, and that could result in laying off many employees, like Morales already explained. That downsizing is probably the inevitable side effect of how transformation and business digital transformation is done. Yes, that's how I see it, Chris.
Yeah, James, go ahead.
Yeah, thanks, Chris. And just to piggyback off Ibu Alex's very pertinent comments about technology and the impact of COVID and the trickle-down consequences for employment, a few insights from the dispute resolution space about technology and COVID. Because one of the main lessons we've learned is to embrace technology more as a tool to conduct cases and reduce time and cost. And one of the main ways this has happened is that parties, lawyers, arbitrators, we've all been forced to abandon planes and hotel rooms to attend hearings all over the world and instead replace it with Zoom and other platforms. Hearings are instead being conducted from kitchen tables and home offices instead of Maxwell chambers or five-star hotels. And I've even been in hearings where translation and transcription have been conducted remotely from across the globe rather than physically in the same room, and to great effect. Also, arbitrations have gone paperless in this time. Hearing bundles, documents have all been collated, stored, and displayed electronically rather than in hard copy. And I think an interesting lesson that we're learning is that this is going to remain for some time. Just because people have realized actually this technology now is reliable enough, it's affordable enough to deploy on a daily basis. And I think that in most cases, procedural hearings at least will be conducted just like we're discussing now on virtual platforms. And main evidentiary hearings, even in smaller and more less complex cases, they will also be held by Zoom. Obviously, the cost saving is going to be immense. The environmental benefits are going to be great. So the rise of e-arbitration and use of technology as a consequence of COVID is going to end up with many unforeseen consequences, I think, including in terms of greater diversity of arbitrators, because there's going to be less focus and emphasis placed on the physical location of where people are and more on the capability of technology and how we can connect using it.
Oh yeah, I think it's sort of a fact that we often don't take into consideration, but in an arbitration, actually having to physically go to Singapore with my staff and the legal expert, my legal team, maybe the finance director or whoever, that is a big part of the cost, James. If we can eliminate that by electronic means, I think it's in everyone's interests completely. I'd like to shift the conversation a bit. Morales, sometimes I've heard you say to friends, I've overheard you say, sebelum hujan, menyediakan payung hukum. And this is sort of like some sort of legal joke I don't understand, but I think you're referring to the omnibus law, which is the legal umbrella. Could you tell us, for people in the business sector, it's as if there's two different legal regimes and they're not sure which one will prevail. How do you advise them in such a case?
Yeah, thank you, Chris. Yeah, it's sedia payung sebelum hujan anyway. But yeah, there's as we may be aware that omnibus law, the job creation law, has been challenged in the constitutional court, Chris, and the judge of the constitutional court has already decided that the existing omnibus law is conditionally unconstitutional at the moment. However, and it needs to be adjusted within the next 2 years. However, please also be noted that that decision from the constitutional court was not to revoke the enacted omnibus law. Therefore, in my perspective, and theoretically, it's still valid, because we also need to be aware that there are at least 4 implemented government regulation that has been enacted in relation to that omnibus law. So yeah, there is, I need to admit that there is an ambiguity in the regulation itself, based on the the judicial review. However, even though the previous the previous employment law still still valid, still enacted at the moment, however, several several provisions have or had revised in the omnibus law, and also in for at least government regulation. Therefore, the companies need to be updated with those regulations, the newly enacted provision related to the employment law in the omnibus law and the government regulation. Chris, I hope that's clarified the ambiguity of the regulation itself.
Yes, would you like to add anything, Ibu Alex?
I'm sorry. Yes, please. Yes, please.
Would you like to add to that? I think the confusion over the omnibus law, in theory, they have 2 years to amend the omnibus law. Do you think that it will be amended and that the omnibus law will be the prevailing law going forward?
It's hard to tell, because the omnibus law, when it was first enacted, it was really a breakthrough, because one law surpasses so many law, that not only employment law, but also forestry, mining, and palm oil, and so on. So, but it's with the transition, already came out several implementing regulations for each sector. So maybe it still stands because it's it will still need time to be more realized in the specific sectors and industries. And what I see could come more are the more technical implementing regulations for more heavily regulated industries, such as mining. And employment, I see for employment, I see there are still coming some in government regulations, right? Just last year, I saw about 10, I think, for employment sector. So I would say that we could be excitingly wait for more regulations next year to further implement the omnibus law. I understand it is not without fights and protests from other parties, but the law itself was meant to really break through, especially for investors. And what I know, the president's message is quite clear, to attract more investors coming, so there could be more projects and more job creation and so on, job opportunities, and I think that's the core message of the law. Thank you.
Yes, yeah, it's very interesting. The government seems to like these sort of sui generis institutions and moves. I have one last point I want to ask James, but in the meantime, please, everyone, feel free to use the Q&A feature for questions, because we are very soon going to pivot to the crucial part of our talk where we accept Q&A. James, all this seems to be going against globalization. Countries are retreating. the idea of the omnibus law was to bring in foreign direct investment, but in fact, because of we've seen counter forces with COVID, and now with this wave of inflation, countries seem to be looking to their own interests. And do you see this on the ground in SEAC? Is it going to become more relevant than ever, or will it become less relevant? What do you think, James?
Well, I mean, one arena where your observation is very pertinent at the moment, Chris, is in the investor-state arbitration space. And here we have a number of countries in the region, including in particular my country, Australia, and the country of many of the people on this call today, Indonesia, retreating from the investor-state dispute settlement system, or even cancelling investment treaties. And the consequences of this retreat from investor-state dispute settlement is yet to be seen in terms of its impact on encouraging foreign investment. Interestingly, the recent Regional Comprehensive Economic Partnership, which some dozen or more countries in our region are now parties to, it's the largest international investment treaty bloc in the world, has parked the issue of investor-state dispute settlement. The parties who signed up to the treaty basically agreed to agree later whether ISDS will be included as part of the treaty. So I think that gives you a bit of a flavor of you know, how this is all playing out at a time when there is a great focus on trying to emphasize and encourage foreign direct investment in our various economies. There's a retreat from the long-standing system of resolving disputes arising out of those investments in the treaties. So as I said, kind of it's a watch this space kind of territory, but it's very interesting that Australia's closest neighbour, Indonesia, we're definitely added in on this issue. So watch this space.
Thank you for that. I think now we're going to move on to our Q&A session, and we have a number of questions, and they're not addressed to any one person, so please answer as you wish and feel free to jump in. I think the first one, though, is clearly for Morales. It's about what is the impact of termination on a company? Could you please elaborate, Morales?
Yeah, Chris, just like I mentioned in the beginning, this termination, this downsizing of the employment is just like two sides of the coins, Chris. It depends on how you know, what perspective you're going to look at, because from, let's say, for example, for the company perspective, this downsizing not always to be, you know, interpreted as a, you know, as a good way, because sometimes the company, you know, loses their potential, you know, good employee, and for that reason the company find it difficulties to finding replacement for that employees that has been terminated. And also, you know, maybe due to, you know, termination, that employee will, you know, leak some kind of company secrets, because as in Indonesia, non-disclosure agreement, even there is non-disclosure agreement, it's hard to you know, to pursue it in the court. That's one of the things from the company perspective. On the other side of the story, let's see from, for example, from the employee perspective that has been terminated by the employer. Of course, they, especially for someone who only have one source of income in their family, because they need their income to be, you know, to feed up their children, to school fees and anything. then I would say this is some kind of, not Pandora, it's like a dominoes effect when the society, when the community, most of them losing their job, and then of course it will be also an impact for the business sector itself. Let's say for simply F&B business, Chris, for example, because when someone losing their job, maybe when usually they tend to, dine in a restaurant, maybe at that point they need to, to cook at home, to eat with their family, not to eat in a restaurant. Of course, when the restaurant hard to, to maintain the stability of the, the income of the business itself, and there will be more and more employment termination. I think that's also one of the impact of the, termination of the employment. It's it's bad whether you are in the employer's perspective or the employee's perspective. Of course, this downsizing, as Bu Alex mentioned, sometimes is an avoidable situation. So in 2023, even if we see it from the news, in the beginning, we also have discussed about in startup, many unicorns in Indonesia. If we see it on the news, massive layoffs is now become very common. So in 2023, I hope that the employers, the business actor can be more careful, especially in, on the scheme of the employment relation itself, whether you want to employ them in the fixed term employment contract or it's for permanent. It's you need to the employer, the business actor needs to, to conduct sufficient analysis before engaging with the employment with their employee. I think that's it from me. Christopher, maybe Bu Alex or James would like to add something to that. Thank you.
Thank you, Morales. I have a question here from anonymous attendee. It looks like it's directed to James. What is the success rate of SIAC?
Thank you, Chris, and thank you for that question, which is actually an excellent one, because the first issue is, how do you define success? If you ask most people, success is when you're able to take an award and turn it into money and recover your financial interests or assets. If you listen to the accepted wisdom of anecdotal evidence and the very limited available empirical evidence, the suggestion is that most arbitral awards, including those rendered at SIAC, are voluntarily performed. And some statistics say that it's upwards of 90% or more of awards. So that you only have 10% or less where you have to have some kind of fight on the basis of the award to try and get your money. I would say that that is a very high success rate if you're measuring the success of SIAC arbitration in those terms. The other thing that I'd say is, even when you get to that lower than 10% amount of awards where you need to try and have some fight to get your money after the arbitration, if you look at the cases coming out of the Singapore courts, the number of cases where an award is successfully set aside in proceedings before the Singapore High Court or Court of Appeal, they are very, very low. The courts always, almost always, seek to uphold the enforceability of awards in the event that one of the very limited grounds for setting aside under the law and the New York Convention can be satisfied. So that's the kind of long answer to the short question about how successful is SIAC arbitration.
Okay, thank you, James. Next question from Kedik in Indonesian. Here, I will. Bagaimana solusi untuk perusahaan atau industri yang sudah eksis untuk tahun 2023? With regard to a company which has been existing up to 2023, and the minimum wage will go up next year, as we know, the tax regime is very tight, very strict. And the rules and regulations are not clear between if we look at the central authority and the regional authority. So kita butuh saran untuk menghadapi hal tersebut. Terima kasih. So how will they, if you are a legal counsel, how do you deal with such a situation? And I leave it to Alex or to Morales to answer.
I'd like to first comment on that. Probably it would heavily depend on the industry of the company. If sales are impacted or companies are having ongoing projects and deals or having contracts with government and so on, that would also have an effect on how to deal with 2023. But in terms of employment, I agree with Morales to really develop an HR strategy and talent strategy, to cope up with the WMP, of course, the provincial minimum wage, because it has to be met. Although companies who are struggling financially can ask permission to be allowed not to implement for several amount of time, and when their finances and income are getting better, they can start complying. I think that for employment, and going further, what is more important is how payments for commitments are met, and if there are concerns about assets are limited and resources are not really coping up with the amount of obligations, then probably you can start preparing, proposing terms, just or starting restructuring. So you are not suddenly being involved in litigious proceeding, just to anticipate the future claim. Thank you.
Okay, I have a question here, which is quite technical. So I will throw it to Morales, of course. From Nissan Foods, Indonesia, from Bapak Takim. I would like to ask you, what do you think about MOLHR regulation number 18 of 2022, mengenai wages? Does it contradict the omnibus law?
Okay, so thank you, Pak Mustakim, for the question. But to answer this question, I don't think there will be a short answer for this, because I need to know in what perspective Pak Mustakim thinks that this MOLHR regulation, the ministerial regulation number 18, is against omnibus law. In what sense? Because as far as I'm concerned, also in the previous question of the participants already mentioned that related to the wage, recently the government already decided on how they are going to increase the maximum of the minimum of wage. So I think for Pak Mustakim, I will be more than happy to discuss this question with you further, maybe with an email or just leave a message directly to my email, because I need to know further in what perspective you said that this against the omnibus law, because maybe we do have differentiate perspective in relation to this law. I think that's it from me, Christopher. I think if Pak Mustakim loves to, and I think we can discuss it in a separate discussion.
Sure, sure. I think I should make a note that if you do have questions, I think you can direct them to the emails. We can provide you with the emails of the speakers, and they would be delighted to go into more detail. Some of these technical questions, it's difficult to answer off the cuff. Another question from anonymous attendee. If for efficiency reasons, are there laws and regulations to fire an employee purely for efficiency reasons, not going into arbitration at SIEC, but simply to reduce the employee headcount? Is it legal? And anyone who wishes to answer.
Morales, do you want to comment first?
Okay, so thank you for the question. So related to the efficiency, if we refer to the previous manpower law, actually there is a term of efficiency when you want to, to terminate the employee. However, if I'm not mistaken, several years later, there are also judicial review case from the Constitutional Court already decide that efficiency is no longer valid. However, if we refer to the omnibus law and the implemented regulation of government regulation number, if I'm not mistaken, number 35, 2021, the efficiency is, it's completely 100% legal. So it depends on how the company wants to take it or not. But of course, the company, when they want to take this step to related to the efficiency to terminate the employee, of course there are other obligations to be fulfilled. For example, the severance pay, the calculation, I think is now quite clear if we refer to the government regulation number 35 2021. I don't think as I mentioned before to the one who questioned this, termination due to efficiency not always interpreted in a bad way. Sometimes the company already conduct their their analysis, and this is the last resort to be taken anyway. So yeah, it can be done. It's permitted by the law. However, the law itself already, already regulates on how you want to, on how you have to deal with it, how you deal with the severance package, how you deal with the, the any payment needs to be paid to the employee in the event of the termination due to efficiency. I think it's completely legal if we refer to the newest enacted regulation. Great.
Thank you, Morales.
Yeah,
we're running out of time, but
okay.
I think that's the last question. Oh, sorry. Did you want to chime in, Alice?
Just a bit, because
Sure.
efficiency often comes from corporate restructuring, and in many cases, reorganization comes because the ultimate shareholders is also experiencing reorganization. So while it can be done and it's allowed by the law, as Morales explained, it will help convince it comes to dispute on employment and on the reason for the efficiency. It may help the company if there is a ground or corporate approvals or corporate decree about the efficiency that it has to be done. That it's not only one company is affected, but for example, the whole group or the whole subsidiaries in the region and so on. It could be very practical in the end. Thank you.
Okay, thank you. And this is quite convenient. The final question is actually will allow us to make some conclusions and to sum up from Liasta Caro. Her question is, what should our strategy be to handle business, and how will business survive in the recession in 2023? Yeah, go ahead, James.
Oh, just very quickly. Well, I'll speak from a disputes perspective, and I think companies should be adopting a dispute proofing strategy. They should already be doing due diligence on existing contracts, especially in terms of their force majeure and frustration clauses. For foreign investors and states and state-owned enterprises, they should also be conducting due diligence on potentially applicable investment treaties and their scope of application. Companies should be getting organized in terms of anticipating emerging disputes. They can already be marshalling potential evidence, collating documents, and identifying likely witnesses. These are all things that are very difficult to do in the throes of litigation or arbitration after proceedings have already commenced. It can be very time consuming and consume a lot of money. So if you're able to do this kind of due diligence at the early stages of a severe economic downturn, in terms of things that will likely impact your business or contracts or investments, then you're going to be ahead of the game and already on track to winning your case before the case begins. So that's just one perspective.
Sure.
I may.
Yeah, go ahead. Anyone else?
Thank you.
Yeah,
I may add that first of all, I think you have to determine what industry or what sector you want to enter into. For example, if it is very retail, then you have to think whether you really want to open offices, or you want to go fully digital, or you want to enter into an e-commerce and so on, because eventually it will lead to consideration how much investment you want to make to a new business. And secondly, I agree with James that having an enforceable dispute resolution mechanism and a clause in a contract will really help in the end, because once you enter into a contract, parties are very reluctantly wanting to consider whether we will go to dispute, whether we will fight, and so on. But it will really help the deal and the project in the end if you have a dispute resolution mechanism agreement. So many examples we find in practice. There are unenforceable arbitration clause, or even clause referring to a court which does not work. And it's a pity, because if you we can find many module clauses, standard clauses, for arbitration right, James, and also in SIAC, you can easily find it in the website, and it will really help in the end. Thank you.
Okay. Morales, do you have a final comment, or should I sum up?
Yeah, just want to add a little bit from the perspective of the employment. I just want to emphasize that as the employers, the business actor might prepare to consider to, maybe, as I mentioned before, whether they want to adjust the production capacity in 2023, or there are several things that can be, several costs that can be, to be cut off during the recession, at least to save the, the hard path of downsizing of employment, or maybe to follow or to keep updated with the current market, the current trends. For example, let's say in the mining industry for coal, maybe due to, past experience to the energy, most of the company now are shifting, or at least they are now try to exploring the new opportunity in new green energy. So I think that things need to be considered as the business actor, as the companies. But of course, this all can be done after the companies, conduct internally comprehensive review and analysis. Chris, I think that's it from me. I hope that it answered the question.
Okay, thank you all for your participation today. I think there were a lot of valuable insights. And just to sum up, I think what James tried to impress upon us is that SEAC has been very proactive, and they are trying to enable these sort of cost-effective solutions, leveraging off digital platform and digital technology to make things better for everyone, actually, to streamline business processes. And if we do have to go to SEAC, that is not the last resort, but I think if you must go there, I think they've taken many measures to make it as seamless as possible. If you must downsize your company too, I think Morelos tried to impress upon us that it should be done in a strategic way, because it will have it could have, if done improperly, it could have a very negative impact upon the company culture, and the very business model of the company. So I think he's encouraging us to think strategically in that regard. As for litigation too, I think Alex has impressed upon us that we should always attempt to find alternatives, to litigation. It is really the worst case scenario when you must enter into litigation. Try to find alternatives to litigation, whether it be mediation or some sort of amicable settlement. I think overall in this webinar, we've been trying to, we never claimed to give you a detailed action plan. What we wanted to give you was just some ideas on a strategic level, and it's up to you, sector by sector, to implement that, to turn it into an action plan, because frankly, many of these considerations are sector specific. If you want to fire someone and you're an insurance company or you're a mining company, actually it plays out very differently in Indonesia, right? There are sector specific laws too for hiring and firing and all other sort of matters. So we hope that we've given you a lot of food for thought, and that this will put you on the path towards preparation. Because as Morales said, sebelum hujan menyediakan payung, in Indonesian, before it rains, bring your umbrella, carry it with you before it rains. Yeah, so that is the theme of the seminar, to always be ready for the coming storm, for the coming zombie, Godzilla, Pandora apocalypse. Thanks to everyone, and I turn things over now to our MC, Liza. Thank you.
Thank you so much, Chris. It was fantastic, Christopher Johnston, with all of our panelists at the first session of ADCOTalks today, Alexandra Gerungan, Morales Sundusing, and James Morrison. It was so insightful and certainly opens the horizons of knowledge for all of the audience. Of course, we still have a second session, which will start at 1 p.m. this afternoon. For those of you who have listened to the remarkable discussion in this first session, we would like to invite you to come back for the second session. Before this first session ended, I invited our moderator, Christopher Johnston, and all of our panelists in this first session, Alexandra Gerungan, Morales Sundusing, and James Morrison, to take some photos together. Please show your best smile. I will help you to count. 3, 2, 1. Once again, 3, 2, 1. Okay, thank you very much, Chris, Alexandra, Morales, and our guest speaker, James Morrison. Thank you so much. Chris, Alex, Morales, and James, you can leave this discussion session.
Thank you, Lisa.
Thank you.
Thank you so much.
Have a great day. Goodbye.
Goodbye,
Bye.
James. Ladies and gentlemen, I remind you again that ADCOTalks is not over yet. We still have a second session, which will start at 1 p.m. In this same Zoom webinar. We will discuss the global economy and corporate actions in the midst of global recessions with Alta Mahandara, our partner at ADCO, Roy Sibuya, director at EY Indonesia, and Marius Toimi, partner at KL Gates, and will be moderated by our partner Dendi Adisuryo. It will open your eyes to various corporate actions in dealing with the global recession. Selamat beristirahat dan sampai jumpa kembali pada sesi diskusi kedua di Zoom link yang sama pukul 1 siang hari ini. Ladies and gentlemen, thank you and see you later.
you.